my pleasure to have you with us this evening as we're going to be presenting, a program for you on estate planning. So happy August, and we're coming into Labor Day weekend as we're looking at this. So welcome. Our guest speaker this evening is Michael Kanarek of Kanarek and Kanarek. Mike has had years of experience in the area of estate planning. He's personally worked with our organization as far as in representing clients in very sophisticated estate planning areas. And so, Mike, it's always a pleasure to have you with us and, to spend time with you. So thanks for being with us tonight.
Thanks for having me.
So, Mike, it's interesting is I'm doing this many years. And I always say is, people have an estate plan. It's either one they choose or one they don't choose. The one they don't choose is when they do nothing. And basically their estate plan is whatever the state says it is.
That's right.
And so what we want to spend our time on this evening is maybe speaking to, the one that they get to choose and giving just some perspectives on, how things work, what they are. There's a lot of terminology out there and fancy words like trusts and things of that nature. And so maybe what we can do is kind of dive in a little bit and give kind of an overview for everybody as to, what's going on in the world of estate plans and even from a taxation standpoint, because people sometimes will look and they go, oh, I don't think I have any tax. And then when they find out what does an estate, actually equate to, they find out by surprise sometimes that maybe they might have a taxable estate. And then the last thing is, I don't know about you, but it seems like every time I turn on the news, I hear there's a new tax plan. Somebody's got their own agenda with a different tax plan. One has that one thought. And my almost or a little over 40 years that I'm doing this, I've seen numerous changes in the laws, numerous ways of, how they view estates and the laws and everything else. So it's not a topic that it's a one and done.
Right.
It's one of those that you've really got to be working. It's a moving part, target that we've got to work with. So having said that, how about we just dive into it?
Sure.
Very good. And so for our audience, I am a little technologically challenged. But by the way, and I always say, and Mike is an attorney, as I mentioned before, but for our attorneys, make sure that we always put this up and say that any questions of legal advice, tax advice, or whatever, you should always see a qualified professional. Mike, fortunately, we brought our own qualified professional tonight, so we've got somebody with us. But if you have any specific questions, you should really check with your advisors, your attorneys, et cetera, or you can always check with Mike offline, who again, Kanarek and Kanarek. So here's the agenda, and Mike, I'll let you kind of jump into it a little bit.
Sure. Yeah. And so this is just a list of some of the topics that we want to spend some time on. You'll see on here, there are several references to tax. So there are a bunch of slides related to tax. Tax in and of itself is sort of a big topic. I don't think we could delve too deep into it today because we do have a lot to cover. But if anybody has any more specific questions on tax, always feel free to reach out to me after the webinar or off, we could talk offline.
Perfect. And as I mentioned before, that whole tax side becomes kind of a moving target. It just depends on, where we are at that point in time, and we just don't know. So we'll take a look here.
So, when people say, what is estate planning? A lot of times people think, oh, I have a will and therefore I have an estate plan. A will is an estate planning document. It is a plan. It just might not incorporate all of the goals I would consider, the goals of estate planning. So I list those on the slide here. Asset distribution, I think, is the obvious one that people sort of think of. My will says where my assets go when I pass. But what people don't maybe pay so close attention to is, how do you protect family? How do we asset protect things? We just spoke about taxes. How do we minimize taxes? There's legal complexities involved in after you pass away. How can you avoid those? And then, for people that have businesses, management of their businesses after they pass. So estate planning really is more than just, hey, I have a will that says where my assets go.
And it's interesting, Mike, that, over the years, one of the conversations that we always have with our clients is, protecting estates. It's, and people oftentimes, and it's very common, they say, I want to take care of my children, my grandchildren, and so forth. And we also live in a world where we have, what I refer to sometimes as unfriendly creditors, and it doesn't mean the IRS, but it could be a lawsuit, it could be divorce. And so somebody's life's work of what they're going to leave to their family, they want it to go to where they want it to go and to the people that they love and care about.
Yeah.
So all of that is really what you're getting into when we're looking at this.
Yes, that's right. So the next slide talks about what the estate consists of. You'll hear people joke around, I'm worth more dead than alive. You'll hear people say that a lot. And that's probably true for almost everybody. The reason is sometimes people feel like the assets that they have access to is what their net worth is or what they're leaving behind. And you forget about things like how much equity do I have in my home? What's the value of my retirement accounts, especially for younger people that aren't going to be accessing those retirement accounts anytime soon. Death benefit of life insurance. That's a big one. People, that might be their biggest asset, actually. If they pass, people have several $1 million of life insurance. Well, you pass, that's several $1 million that's going to somebody. The obvious ones that I think people consider are cash and that kind of thing, or brokerage accounts, stocks, bonds, et cetera. And the other big one that people might miss is business interests for those business owners that have, sometimes valuable businesses. Again, it's not a liquid asset, but it does count, even if it's not liquid, as part of what your estate is when they calculate your tax liability, or when you think of how much you're potentially leaving to your family.
Mike, I find it interesting when you're hitting on all of those. The one, that is the obvious is the life insurance, and that, with the stroke of a pen, something that, somebody writes a check for a premium, all of a sudden turns into a multi-million-dollar asset. But the other one is, sometimes you can have a business interest that, somebody's been just working for years, working at their business, and all of a sudden they don't realize how much that business is actually worth.
Mm-hmm.
And I always laugh when a business owner will say to me, it's like, well, it's not worth as much as I think. I said, well, if you were going to go and get audited by the IRS and they said it was worth a whole lot more than you say, but you're not here to attend the audit.
Right.
So, making sure that, for any of our business owners that may be listening to this, that business estate planning is a really critical part of all of this when you look at it. So we're not going to go into details on that, but it's just something you should be very aware of.
So key components of an estate plan, again, I mentioned earlier wills, and I think that's the obvious one. The other sort of no-brainer documents are the power of attorney and medical directive. Those documents, unlike the will, are effective only while you're alive. The will sort of takes effect after you pass away, but the power of attorney and medical directives are for when you're alive. You may have some kind of incapacitation where you're not able to make sound decisions any longer. That could be Alzheimer's, dementia, you could be unconscious, et cetera. And these two documents will kick in to allow somebody to handle affairs for you, make medical decisions for you. The medical directive can also direct your feelings toward, most people not being kept alive in a vegetative state kind of situation. And then you'll see in the middle here, trusts. Trusts can take effect at death. Trusts can be used while you're alive, and we'll explore trusts a little bit further down the line in this meeting today.
Great.
So I mentioned earlier taxes and how there's a lot to talk about. So just at a very high level here, the estate tax, sometimes called the death tax, is a tax that they hit you with when you die, depending on who you're leaving assets to and how much you're leaving to them. So you'll see here the two exceptions to the estate tax, which are big exceptions, are the unlimited marital deduction. What that allows you to do is leave any amount of money to a spouse without paying estate tax. So even if you have $1 billion, you could leave it to your spouse. That will not be subject to the estate tax. Of course, then your spouse will have $1 billion. And when they pass without a spouse, that's when the estate tax kicks in. The other exception to the estate tax is the estate tax exemption. The estate tax exemption allows for you to pass a certain amount of assets to non-spouses. So for example, your children would be the big one. Under the current law, well, we'll see it in a second. So I'll pause here on the numbers, but
it's almost like a deductible when you think about it.
Yeah, that's right. So you'll see on this slide here, the current estate tax exemption is $13.61 million per person. As we'll see in a second, don't get too excited about that number. That might not be here for too much longer. The current exemption is indexed for inflation, so it does go up slightly each year. In fact, the actual exemption written into the law right now is $10 million. It's just made its way up to 13 million over the years. That number can be reduced if you do make gifts while you're alive. And that number can also be ported spouse to spouse. What that means is if one spouse doesn't use their estate tax exemption, the other spouse can grab it and tack it onto their own estate tax exemption, in really doubling the estate tax exemption for married couples. As far as a rate goes, if you go over the exemption, current tax rates are at 40%. Historically, believe it or not, that's kind of on the low side. When I started practicing law, state tax rates were 55%.
That's what they were when I started in this.
And under the latest plan that Harris put out there, and again, I'm not so sure that will be adopted even if she's elected, but you never know. State tax rates were really climbing up even higher than 55%. I saw it there. So.
You know, it's interesting is, Mike, we talk about, and you're going to go through it in a second, is, I've seen rates as high as 55%, but that exclusion was nowhere near 13.
Nowhere near. When I started practicing law, the exclusion was $675,000.
And it was, so I was slightly before that. it was a $600,000 exemption when I started. So you were a few years after me.
Right.
And, then it went up, and then Mike, I'll let you hop into what occurred then over time.
So this chart here shows, what the current law has looked like over the last few years. As I mentioned, there's a inflation adjustment. So this shows each year how that inflation adjustment has affected the rate. We'll get another inflation adjustment, for next year in 2025. But as you can see, in 2026, the estate tax exemption drops back from 10 million down to 5 million. Under the current law. Again, it's hard to say whether the current law will hold. Potentially if Trump is elected, he might extend the high exemption, the $10 million exemption. If Harris is elected, she's got a plan out there right now to lower it below $5 million down to $3.5 million. So it's pretty hard to say. Under the way the law is currently written, though, the estate tax exemption will drop from 10 to 5. The slide might be a little misleading because the current law still does allow for the inflation adjustment to take hold. So probably more like 7 million-ish if things hold as they are.
And again, nobody knows what it's going to be because nobody knows the day they're not going to be here.
Yeah,
So
I mean, right. That's the thing I
to-
talk to a lot of my clients about, especially those that are on the younger side, is whatever happens under Harris or Trump probably has no effect on you because the law will be totally different by the time you pass. I don't know whether it will be higher. I don't know whether it will be lower. I mean, sometimes these deaths occur 50 years from now. So if you want to look back 50 years from today and what the tax law looked like, it doesn't look anything like it does now. So it might not look anything like it does today, 50 years later.
It's a great insight. And so, what I always say, and one of the reasons why we love working with Mike is when an estate plan is put in place, one of the key attributes of the plan is that the plan should be flexible enough that whatever the law is at that time, the plan can adapt to that, either taking advantage or not wanting to take advantage of that law. So
Yep. Yeah.
That's one of the benefits of good estate planning.
Yep. And we've been talking this entire time on tax law about the federal estate tax. So this slide also brings to light that there's state estate and inheritance taxes. I'm throwing up 3 of them right now, mainly because I think most of the people on this are from these areas, and those are the 3 states I'm licensed to practice law in. So I'll talk about that. So just real quick, New York, they have an estate tax exemption that's currently $6.94 million. The big difference between the New York law and the federal law, and there's some other slight differences about the way it's calculated, but the big one is that there is no portability in New York. So the idea that what we talked about before, where one spouse can port the other spouse's exemption and sort of double the estate tax exemption, that doesn't exist in New York. You need to use certain strategies in order to take advantage of both exemptions. The New Jersey and Pennsylvania, they use an inheritance tax, not an estate tax. For the folks in New Jersey, most of you probably have nothing to worry about because the New Jersey inheritance tax is 0%, not only to spouses, but also to descendants or ascendants. So we're talking about parents and grandparents would be your ascendants, children, grandchildren, down the line would be your descendants. So usually estate plans provide for those classes of people, and therefore are not going to end up being subject to New Jersey inheritance tax. The big one I think to be careful with these days, again, there's some obvious ones on the screen, siblings and in-laws and that kind of thing. But the big one that can really get you are couples that aren't married. We see that more today, where you have couples that are together, they have families together, but they're not actually married. Those couples are going to be subject to the New Jersey inheritance tax, although there are, as you get older, there's potential ways around that. But that we can get into more details offline if someone's interested. Pennsylvania, they do tax ascendants and descendants. So people that live in Pennsylvania, when you leave assets to your children, there is a 4.5% tax, and there is no exempt amount. You can leave them, $10,000, and it's going to be subject to the 4.5% tax.
And the reality is, and again, good planning is you make sure that your documents are flexible, but you should know in this state that you live in. I remember years back, and Mike, you probably remember this, people would retire, they'd get older, they moved down to Florida because there was no tax. And then New Jersey said, wait, we're losing all this income tax of all the people from New Jersey going down to Florida. So New Jersey came around and did away with it. So you're okay to be here, later in life.
Yeah.
It's all good.
So this slide here, it talks about the unlimited marital deduction. We spent some time on this a few minutes ago, and for time's sake, I think we could sort of skip through this one.
Perfect.
Just real quick on this one. There's a few things to note about the unlimited marital deduction. The obvious way to get it is to leave the assets directly to your spouse. So one spouse dies, the other spouse gets everything. That clearly qualifies for the marital deduction, right? But what if you don't want to leave the assets directly to your spouse for certain reasons? Perhaps you're in a second marriage and you have children from the first marriage, and you fear that if you leave your spouse all of your assets, that your spouse, when they pass away, won't leave the assets back to your children. Maybe they have their own children, and you sort of get an order of death thing, determining who ultimately gets the money. If the husband survives longer than the wife, the husband's kids get it. And if the wife survives longer than the husband, the wife's kids get it. That's not great planning.
By the way, it is common though.
Yeah, this stuff happens. So you might want to leave the assets to your spouse in a trust, so that your spouse has access to assets, but not necessarily control over where those assets end up. And there are many different kinds of trust you can create for your spouse, but only one kind of trust will qualify you for that unlimited marital deduction. That trust is known as a QTIP trust. It stands for Qualified Terminable Interest Property, which is not important. But it is important that if you're not leaving assets directly to your spouse, that you know how to structure this so you can assure yourself a marital deduction. The other thing that's noted on here is a qualified domestic trust. That is because even if you leave assets directly to your spouse and the spouse is not a U.S. citizen, you do not get that unlimited marital deduction. Those have to be left to a special type of trust known as a QDOT trust. It's kind of similar to a QTIP, has some rules around it. Again, not worth delving into the details in it here, but just note, if you're in a relationship where either one or both members is not a citizen, there is some tax stuff to talk about there. It's not so simple.
Perfect.
So a tax shelter trust, and again, I don't want to spend a lot of time on this. But the tax shelter trust is something you can build into an estate plan to help reduce the size of the estate tax liability. Generally, when the second spouse dies, usually we don't have much of an estate tax at the time of the first death due to the unlimited marital deduction. However, for estates large enough to have a tax at the second death, there are some tricks you could play at the first death to try to reduce the amount of taxes due at the second death by using tax shelter trusts. And again, happy to talk offline in more detail about that. I always spend some time on this in meetings with my clients when I first introduce them.
So for our guests and the people that are watching this, the takeaway hopefully should be is that trust can really be worked into what you'd like to accomplish. I always say is it's a way to have your form of management of what you like to see happen when you're not here for extended periods of time.
Yep. All right, dynasty trusts. So these types of trusts, I am a very big proponent of. I think most of my clients, after having it explained to them, become very big proponents of. And these trusts usually are set up for the benefit of your children. A lot of times we'll review estate plans where if the kids are above a certain age, they feel there's no need for trusts, right? So my kids are, if they're little, I get it. I don't want to leave assets directly to my kids. They need to be monitored and under somebody else's control. We'll use a trust until they attain a certain age. With dynasty trusts, those are set up regardless of how old the children are, and they stay in place throughout the lifetime of the child. And they provide several advantages versus just leaving money directly to a kid, at a certain age. So one of those advantages is asset protection. If you leave money to a child and then the child later gets divorced or gets sued or has creditor issues, their money can be up for grabs in those situations. Leaving money in trust for the benefit of the child will generally keep it protected and not up for grabs in those situations. The other thing that people really like about dynasty trusts are that trusts have remainder beneficiaries. Remainder beneficiaries dictate where the money goes at the death of a primary beneficiary. And I can use myself as an example. Okay, I have two boys. I'll pick on the older one. His name is Ozzy. If I leave money to Ozzy, and he's a teenager now, so I would never do that. But if he was older and I left money directly to him, when he passes later on, and let's say there were no issues with divorce or lawsuits or any of that, but he passes later on and his spouse is alive. Most of the time, people's assets pass to their spouse when they die. So what would happen is money would go from me to Ozzy, and then Ozzy to his spouse, and then hopefully back to my grandkids one day when his spouse passes away. But I have no assurances of
That hopefully word I didn't like so
Yeah,
much.
right. Because why might those assets not end up back to my grandkids? Well, his spouse can remarry. That's certainly possible. His spouse can spend or use all, blow all the money on something. By using trusts, what would happen is when Ozzy passes, the trust is set up already that when he passes, even though his assets might be going to his spouse, my assets, the trust assets, will be going to his children, my grandchildren. And it's also set up to say that if he passes without children, then my assets go to my other son, Nate. This way, I'm assuring that assets are going to stay within my family and not end up with my in-laws. Right.
Or whoever they may marry.
That's right.
Down the
So
road.
that really dynasty trusts are, a big one for me and my clients.
I was gonna say, pretty common for almost every case that we do together.
Yes, yes. So this slide is a very important one. People commonly think, okay, I have a will. It states where my assets go. I really like that dynasty trust idea that you talked about. I really like that tax shelter planning that we talked about. Put it in the will, great, and we're good to go. We're not good to go. The will doesn't control all of your assets. In fact, a lot of times the will controls very few of your assets. So certain assets pass pursuant to beneficiary designations. Big ones would be life insurance policies, retirement accounts, transfer and death accounts. Those pass pursuant to beneficiary designations. So if I'm working with a client and they like the idea of leaving assets to their children in trust, and I do the will that says, leave all my stuff to my children in trust, but the life insurance policy names my children directly as beneficiaries, right? When I set the policy up, it was sort of a knee-jerk reaction. I made maybe my spouse as the primary, my kids as the backup, and that was that. Well, the life insurance company doesn't care that your will said leave everything to a trust. They look at who's the beneficiary of this policy, and that's who's getting a check. So you can lose a lot of the planning that you thought you were doing by not paying attention to how your assets pass. So when we do estate planning, we want to look at all the beneficiary designations that a client has. and say, okay, if your kids are listed as the beneficiary on your life insurance, as an example, but you told me you want all your assets to pass to a trust for your children, then we need to change the beneficiary to the trust for your children, not your children directly. This holds true for transfer on death accounts, retirement accounts. And the other one listed on here is jointly held assets. Jointly held assets pass to the surviving joint tenant. It really makes no difference what your will says. So Frank, if you and I own an asset together as joint tenants, and I die, even though your name is not mentioned in my will, you would still get my share of that joint asset. You'd end up with the whole joint asset. That can be problematic for people that aren't, wanting that result. Very, Q-tip trusts, when people have that situation where there's children from different marriages and they like the idea of using the Q-tip trust, and then we build that into the plan, but then it turns out all their assets are jointly held. Well, guess what? Everything's going outright to your spouse and not into the Q-tip trust. So we really need to be paying attention to how assets pass, whether it's through a will or not.
And just a little caveat for our business owners is if you've got a business agreement that says that when you're not here, that your business interest has to be sold to your partner or whatever, or if you don't have that, then it's going to the will. But if you haven't stated that it goes through the agreement, these are all things that have to be coordinated to work together.
Yeah.
So it requires some good planning there.
Right. A lot of people ask about revocable trusts or living trusts. So you can see here on the slide the difference between a will and a revocable trust or revocable trust. The big reason, okay, the big thing here is that revocable trusts, owning your assets in revocable trust prior to your death, okay, allow you to avoid probate at the time of your death. Right. Having a revocable trust, but not having it own the assets prior to your death, just having your plan say, when I die, put everything in the revocable trust, that does not avoid probate. So for example, let's say we're talking about a house. If the house is in your name, even if you have a revocable trust, the house is going to need, that probate needs to take place in order to transfer the house. A new deed would need to be done to change title to the house so that it's now owned not by you, but by the revocable trust. All right. So you'll see some things on here that, the fourth one down, less time and cost now, more time and cost now, more time and cost later, less time and cost later. So the question is it worth going through the rigmarole of having a revocable trust drafted and then retitling all your property, the deed to your house, the ownership on your accounts, all that stuff to avoid probate? And a lot of times you will see generic advice that says, yes, that is worth the trouble. Probate should be avoided at all costs. Probate has a stigma attached to it. That may or may not be true. All right. I think people are confused about what probate is. So just to spend a minute on that here, let's use a house as an example. All right. Let's say I own a house and now I pass away and I have a will that says the house, all my assets go to my children. So the house now should go to my children. Okay. And let's pretend they're adults at this time. My kids want to sell the house and split up the money. They have no right to sell the house. It's not their house. Right? I get that it's my house and I said that they're the beneficiary, but at this point in time, their status as my child or as my beneficiary does not give them the right to sell the house. Right? What happens is an executor is appointed and the executor is given the right to sell the house. Now the will names the executor. So let's just say I named my son as the executor of my estate. Even that, he still doesn't have the right to sell the house because he's named as executor in my will. He needs to be appointed as executor by the surrogates court. Okay, now the surrogates court, generally speaking, will appoint the person that you suggested that they appoint in the will. So if I say I appoint my son, the surrogates court is highly likely to appoint my son, but he still has to get appointed. Once he gets appointed, he'll receive certification from the surrogate's court that he's the executor. It's literally like a kind of a certificate that shows that he's the executor. Once he has the certificate, he can then go list the house for sale, sign sales contracts, and do all that kind of stuff. All right. If the home was owned by a revocable trust, if that was on the deed, the revocable trust is the owner of the home, and my son was listed as the successor trustee to take over trusteeship on the trust after I pass away, then he could sell the house as trustee of the trust because the trust owns the house, not a deceased person. He doesn't have to go obtain paperwork from the surrogate's court in order to be able to sell the house. That's what is being avoided, that process of getting the paperwork from the surrogate's court. Where we live here, well, where I live here, and Frank live here in New Jersey, in Monmouth and Ocean County, and pretty much everywhere in New Jersey, obtaining that certificate from the court, it's really not that big a deal. It doesn't take a lot of time. It's not very expensive. You generally don't need an attorney to help you with it. So my general opinion is that it is more difficult to move your assets into a revocable trust to avoid probate than to just have someone do the probate. Now, in other locations, that is the total opposite. Probate can be extremely time consuming. It could take months on end. It can be very expensive. You'll definitely need a lawyer, and you'll be all kinds of confused, and avoiding it is a really good idea. And simply setting up the revocable trust and transferring your assets, is well worth it. So, using one technique over the other kind of just depends on usually where you're located and what kind of assets you have. As I mentioned before, beneficiary designated assets don't pass pursuant to a will. Jointly held assets don't pass pursuant to a will. They pass pursuant to beneficiary designations or to the surviving joint tenant. Those assets avoid probate as a matter of course. So if all of your assets are jointly held or beneficiary designated, there is no probate anyway. So I think to answer this question of which is better, it's really a facts and circumstances situation, not a blanket statement. Everyone should just have a revocable trust to avoid probate.
As we wrap up on this, Mike, you and I have done many times, sat down with people that have, let's say, a house in Florida or something, in another state, in which case utilizing a trust for that seems to make sense to simplify everybody's life.
Yeah. So interestingly, probate is done. It's within the county that you live in. Okay, so it's by county. So probate's done in the county that you live in, and any other county where you own real property. So if you live in Monmouth County, New Jersey, and the general advice is you don't need to have a revocable trust because probate here is very simple, but you also own a home in Florida where probate's quite difficult, you're going to have to probate down there. Now, it's not a full-blown probate, it's called an ancillary probate, but still, the thought might be, even though I live in Monmouth County, New Jersey, I might want to have at least my Florida home put in a revocable trust to avoid having to deal with the Florida surrogates courts.
So just for all of you, a little sidebar if you needed to know that.
All right, so I touched on these at the beginning of the meeting on these other important documents, and we could just spend a few minutes on just being a little bit more specific about them. But you'll see, here the power of attorney, the healthcare proxy, the advance directive. And so, a power of attorney allows you to appoint someone to manage your assets and your affairs and make financial decisions for you in the event you become mentally incapacitated. I'll give an example again from my personal life. Years ago, my grandmother, she's passed away a long time ago, but when she was alive, toward the end of her life, she ended up with Alzheimer's, having to go into a nursing home, that kind of thing. When she went into the nursing home, my mother had power of attorney. That allowed my mother to sell my grandmother's home. All right. Again, going back to a similar conversation I had a minute ago with who has the authority to sell a home. Well, after you pass away, it's your executor. While you're alive, there is no executor appointed. That only kicks in after you pass away. And again, just because someone's your child doesn't give them the right to sell the home. They have to be named power of attorney. And if you don't name somebody power of attorney, and the home needs to be sold, or it's beneficial for the home to be sold, and let's just say my grandmother didn't have power of attorney, my mother would have had to go to court, be appointed my grandmother's guardian, and then she'd have authority to take over and manage her affairs and do things on her behalf. That's a major undertaking. A power of attorney is a quite simple document. So whenever I do wills for somebody, even if they're, young and they're nowhere near the age of hopefully becoming mentally incapacitated, I'd say, look, we're going to put this in place now, because once you're mentally incapacitated, you can't sign a power of attorney at that point. So it's really good to have that in place, when you do your estate planning. The healthcare proxy is similar. That's who makes medical decisions for you. A lot of times that might be the same person as the person making financial decisions for you, but it doesn't have to be. Right? Sometimes one kid might be more financially savvy and another kid might be more, better to deal with medical kind of stuff. So that is a very important document as well. And the other thing where we're seeing it come up more and more are young adults. Once a child attains the age of 18, you're not their legal guardian anymore. Okay. You might still support them. You might pay for their college. You might pay for everything. You might pay for their health insurance. They might still be on your health insurance plan. You're not their guardian. You don't have the right to decide things for them, and you don't have the right to access their medical information. There's HIPAA laws that protect the privacy of medical information. And it could be a situation where you have a child who's been in an accident or is unconscious, and you want to ask the doctor questions about, their medical situation. Yes, doctors may sometimes talk to the parent, and sometimes they might not. Sometimes they may say, look, you're not their guardian. I don't have the right to talk to you. If a child signs a healthcare proxy in favor of the parent or parents, then the parent will have the right to talk to the doctors and make decisions and that kind of stuff. So it's becoming very big when kids go off to college that they do sign at least healthcare proxies.
I just had one of my friends, their daughter graduated, and the grandmother was taking her out of the country, and they were smart enough to go and have a document signed that if God forbid anything happened while they were away, that the grandmother would be able to actually, act on the behalf and so forth. And I was like, well, great planning. And, so they really did a nice job on that. But those are the type of things that come up.
Yeah. The last thing you see here is the advance directive that conveys your wishes regarding end-of-life decisions. Again, as I stated earlier, usually people want to state that they don't want to be kept alive, like on life support, if it's been deemed that they're, permanently vegetative. So you can express that in the document as well.
For all of our listeners, you've heard quite an assortment of information. There is one trust that Mike is not going to cover, but I'm going to bring it up because I get these calls periodically, and somebody will call me up and say, hey, Frank, I need to set up a Medicaid trust. And that is not what Mike does, by the way. And that is just a trust when people are thinking long-term, and they're thinking if, God forbid, they ever needed to go into a nursing home, and things of that nature. And it goes into a whole nother set of rules and laws and look back periods. It's usually something that's done much later in life. Okay. Typically I find people that are considering that are in their 70s or 80s and beyond. And really not within the scope of what we're doing here. For most of our clients that are in the accumulation stage of life, or their early stages of retirement and so forth, these are really, I would say, the critical documents and the critical planning in the estate plan.
Yeah, and I'll just make one comment on the Medicaid thing, and I am not an expert in Medicaid. All right, there are attorneys who really just focus on that specific area because it is so confusing and full of rules. And as Frank said, he gets this brought up to him all the time. I get it brought up to me all the time, and usually it's brought up in a way that says, what am I supposed to do? Because I heard that if you go into a nursing home, the government takes your assets. That's what I hear regularly. All right, so just to alleviate, any fears of this happening, okay, that's not true. All right, what happens is if you go into a nursing home, they cost money, right? You pay for the home. Medicaid is a program that says, if I have no money, the government can help pay for my care. Moving assets into a trust is generally an attempt to get onto Medicaid so that the government's paying for your care and you're not paying for your care. That's what that's about. But if you're not qualifying for Medicaid, all right, and again, that's usually reserved for people that have no money. There is no government taking of your assets, right? That's for people that are on Medicaid.
It's a great insight. So Mike, as always, it's wonderful spending time with you, sharing information. We love getting on venues together. So again, Mike, thank you for being with us.
Yeah, my pleasure.
Again, Mike
Thanks for
Canarac,
having me.
Canarac and Canarac. And again, I'm Frank Congelos, managing partner here at CNA Financial Group. As always, it's wonderful to be with you. We wish you really a wonderful holiday weekend coming up. And for those of you who are watching this, if afterwards, you'll be looking for our next program coming up in the month of September. And outside of that, everybody have a lovely evening.